And we're back. Part 3 on arguing on why New York is refusing permits.
I'm going to give you.
We did our best to be accurate in reporting what we reported. I don't know what you have in mind.
Yeah, well, I'm going to.
She overtalked the judge, and you normally never want to do that. When they talk, you shut up. So not only is she being rude, but she's getting the quota higher pass. You know, nobody's going to say nothing to her because she's a woman, and you'll be called sexist if you say anything. So she gets to do what she wants. But normally, you would get chastised if you override or you try to talk over a justice when he's trying to make a point. You shut the hell up. And she didn't do that.
Accurate in reporting what we reported? I don't know what you have in mind.
Yeah, well, I'm going to give you an example, which is, it's troubling. I can see how it would slip through. I'm not accusing you personally of anything. But on page 23, you say that in founding-era America, legal reference guides advise local officials to, quote, arrest all such persons as in your sight shall ride or go armed. And this is a citation to John Haywood, a manual of the laws of North Carolina, 1814. So I looked at this manual, and what it actually says is you shall arrest all such persons as in your sight shall ride or go armed offensively. And somehow that word offensively got dropped from your brief.
Oh, nice catch, Judge. They're trying to put some shit past you.
I would
think that's an irrelevant word.
I think it would have been better to put it in and make an explanation, but I do think it's an irrelevant word.
Which is why you left it out. Just admit it, you freaking little cheating liar.
Because we have substantial authority for the proposition that guns were deemed to be offensive weapons. And that's why we have this dispute about whether saying, there are different ways of putting it, offensively or with offensive weapons or to the terror of the people. These either describe a separate characterization, a separate feature that not all weapons have. That's my friend's position on this, or they describe the belief that all such weapons are offensive.
Well, I don't want to belabor the point, but of course if any possession of weapons outside the home was illegal, then there would be no need to put in the term offensively, the inclusion of that.
Well,
term.
There are many other weapons. Usually there's a list that's it's not in this particular instruction, but there will be a list of weapons. They were talking about much more than guns, and it was guns that were said over and over again to be offensive.
So shit, back in the 1800s, they were still saying guns were doing crime instead of people using guns.
All right, well, thank you.
But that's the explanation.
Justice Sotomayor? Justice Kagan?
You started a thought and then you were taken off someplace else, so I just wanted to allow you.
Oh, isn't that nice of her? Mean old justice interrupted her and took her off her point. I've got to protect this poor little woman and get her back on thought.
To finish the thought, what you said was that there was a reason why a sensitive place regime cannot serve as a replacement. And then you were not given an opportunity to say why.
Oh, poor thing. They weren't giving her permission. Because she's a woman. They were picking on her.
So, why?
Well, essentially because there are it would be very hard in the first instance, and I think also not very acceptable in the to my adversaries in the second instance, to specify in advance all the places that ought properly to be understood as sensitive. So it sounds like a very convenient alternative. But, for example, we were talking about Times Square on New Year's Eve. Times Square when the theater district, when commerce is in full swing, Times Square almost every night is shoulder-to-shoulder people. So then you end up having a very big difficulty in specifying what all the places are that have the characteristics that should make them sensitive.
So even if you give them an inch and say, we think it's reasonable to restrict Times Square on New Year's Eve, she just opened the door that it's always busy on New Year's Eve and arm to arm. So therefore, we can just restrict it all the time. That's what government does. Once you give them an in, they're going to run through and kick down the door.
It has, in principle, it has an attractive quality to it, but in implementation, I think it would be unsuccessful.
Justice Gorsuch?
No further questions. Thank you.
Justice Kavanaugh?
No, thank you.
Justice Barrett?
I have one. General Underwood, do you think
Why does she always whisper? Isn't that nice? You have to turn up your microphone every time she talks because she's so soft-spoken.
Heller was rightly decided?
I think there is a lot of support historically and otherwise for it, so I'm quite content to treat it as rightly decided. I think there was an argument on the other side too, but that's true about maybe most of the difficult questions that come before this court. I have no quarrel with Heller.
Do you think that we are bound by the way that we characterized history in that opinion? You know, Mr. Clement has pointed out that in some respects the way that we treated, say, the Statute of Northampton and is different from the way that you argue that we should interpret that and the follow-on, statutes in the colonies. You argue that we should understand those in some other cases differently than we did in Heller. Are we free to do that?
I think you are, because I think the Heller decision made very clear that it was not deciding anything other than the right to keep arms in the home. In the course of arriving at that decision, it necessarily said a lot of other things that led to that decision, but I don't think they are controlling, or I think the opinion itself says we're not trying to do a full exegesis of the whole Second Amendment right, and there's more to be done, and it would be odd and really inconsistent with general practice to treat every sentence or every reference to a historical source as controlling for all time, as distinguished from for the purposes for which it was invoked.
Thank you, General.
Thank you, General.
Thank you, Mr. Chief Justice, and may it please the Court. New York's proper cause requirement is consistent with the Second Amendment because it is firmly grounded in our nation's history and tradition of gun regulation. Now, as Justice Alito said, there's a lot of history floating around this morning, and so I want to be clear that when I say that, I am putting to the side all of the disputed bits about the Statute of Northampton, about the surety laws, and I'm putting to the side laws that restricted concealed carry but did not restrict open carry. And I am focusing on laws that either prohibited or required a showing of good cause to carry a concealable weapon like a pistol. Tennessee enacted one of those laws in 1821. Texas followed in 1871. New Mexico and Arkansas likewise enacted such laws in the years immediately after the ratification of the 14th Amendment. And over the decades that followed, more than a dozen other states enacted other laws that were at least as restrictive as New York's. Like my friends from New York, I count about 20 laws in total that fit that description. Those laws remain in force in 7 states today, and more than 80 million Americans live under their protection. They are, in short, both traditional and common regulations. I'd welcome the Court's questions, or I'm happy to continue.
How do we determine which states we should look to? You focus a lot on Western states, but the West is different. Right?
I agree, Justice Thomas, and I think there might be reason to be skeptical
the West is
about.
Different? Really? Why is the West different? In this United States? Oh, well, when it comes to guns, then we can have different. Otherwise, though, the Supreme Court and the federal judges want to jump over and make all the states comply with everything. But when it comes to Second Amendment, now we're going to adhere to the standard that the West is different. So, but everything else, it doesn't matter. The federal government rule is supreme, and we rule everywhere.
A tradition that's only reflected in one state. I think that's a problem for Mr. Clement in relying on some of the cases exclusively from the antebellum South. But the cases that we're relying on come from the South, like the Tennessee, Arkansas, and Texas law I described. West Virginia had a similar law, as did Alabama, New York, Massachusetts, California, Hawaii. The tradition that I am drawing on spans 2 centuries, going back to the Tennessee law, spans 150 years when you broaden it out to many states, and spans all regions, or virtually all regions of the country. So I think that's the sort of tradition that you can look to when defining a national tradition of gun regulation.
But, I mean, what is the appropriate analysis? I mean, you sort of, I think generally don't reinvent the wheel. I mean, the first thing I would look to in answering this question is not the Statute of Northampton, it's Heller. And Heller has gone through all this stuff. And obviously in a somewhat different context, although that's part of the debate, self-defense at home, this is different. But I still think that you have to begin with Heller and its recognition that the Second Amendment, it has its own limitations, but it is to be interpreted the same way you'd interpret other provisions of the Constitution.
It should be. It ought to be even given more preference because it's number 2. Free speech and right to carry are the number 1 and 2. That's why the founders knew it was so important, because we knew the government would eventually try to take those, because in order to take away freedoms, you first seize those 2 things. As soon as you start controlling speech and you take away a person's right to defend himself against a tyrannical government, government becomes more tyrannical. It's history over and over again if you want to look at history.
And I wonder what your best answer is to the point that Mr. Clement makes in his brief, which is that, for example, if you're asserting a claim to confront the witnesses against you under the Constitution, you don't have to say, I've got a special reason. This is why I think it's important to my defense. The Constitution gives you that right, and if someone's going to take it away from you, they have to justify it. You don't have to say when you're looking for a permit to speak on a street corner or whatever that, your speech is particularly important. So why do you have to show, in this case, convince somebody that you're entitled to exercise your Second Amendment right?
Great point.
So we start with the general question and then get to that specific point from Mr. Clement. As to the general question about Heller, we agree completely that the court ought to apply the method from Heller, which we, like I think all the parties, take to be look to the text, history, and tradition of the Second Amendment right, and we're applying that now to a somewhat different issue with the benefit of somewhat broader materials. Now, as to the question about why do you have to have a showing of need, I think the problem with Mr. Clement's formulation is that it assumes the conclusion. If you had a right, the Second Amendment conferred a right to carry around a weapon for possible self-defense just because an individual wants to have one available, then obviously you couldn't take away that right or make it contingent upon a discretionary determination. But the whole question is whether the Second Amendment right to keep and bear arms confers that right to have a pistol with you for self-defense, even absent a showing of demonstrated need.
I'm not sure that's right. I mean, you would, regardless of what the right is, it would be surprising to have it depend upon a permit system. You can say that the right is limited in a particular way, just as First Amendment rights are limited, but the idea that you need a license to exercise the right, I think, is unusual in the context of the Bill of Rights.
A great point. Do you need a license for your free speech? Do you need a license for your right to protect your property from unlawful search and seizure from the government? Do you need a license for that? Or is it a right?
So I agree with that, but I think I heard even Mr. Clement in response to a question from Justice
He's saying Mr. Clement. Is that other guy a man? Because I thought for sure it was a woman. Sorry, I didn't want to get the pronoun wrong. We know how it is with pronouns. Maybe he's identifying. I don't know. He sure did sound like a woman to me.
Kavanaugh say he doesn't have a quarrel with licensing regimes in general. And I think what that is one illustration of is that the Second Amendment has a distinct history and tradition, and that the way to be faithful to the Second Amendment is to be faithful to that history and tradition and not to draw analogies to other rights with their own histories and traditions.
Well, there's licensing and there's licensing. Maybe it's one thing to say we need to check, make sure you don't have a criminal record, make sure that all the other things you can check on, but not that we assume you don't have a right to exercise
exactly.
Your
So I guess
it's hard to say it without saying it, with exercise your right under the Second Amendment, and you've got to show us that you do.
So we would ask that question by looking to the history and tradition of the Second Amendment. And in Tennessee in 1821, you couldn't carry a pistol at all. In Texas in 1871, you had to have a showing of need if you were going to carry a pistol. And that showing of need was actually much less favorable than the New York regime. In Texas, in West Virginia, and in Alabama, in those laws that we cite, need to carry a firearm was a need that you had to show when you were prosecuted for violating the law. It was essentially a self-defense requirement, and you had to persuade a jury in a criminal trial that you had an immediate pressing need to be carrying the gun when you were carrying it. The laws, of which New York's is one, but by no means the only example, that began to become more prevalent in the
Damn, it almost sounds like he's making the other side case, dude. You're supposed to be representing your clients. Sounds like you're representing the government here.
20th century said, we're going to make that determination of need ex ante. We're going to require a showing of good cause. New York has done that for a century. I'm sorry, Justice Kavanaugh.
This might be a level of generality issue, but I think Mr. Clement responded to some of what you're saying on history and tradition by saying you have to look at carry laws more generally. And there was open carry traditions in a lot of those states. And so that I think he followed up by saying, so open carry is one option, shall carry permit regimes for concealed carry another option, but what you can't have is no open carry and simply a may issue discretionary regime that will, in practice, he says, limit the right. So can you respond to that?
Yeah, I meant to be taking that into account in the account of history that I'm giving you.
It almost sounds like they could force New York to allow open carry if they want to have such restricted concealed carry, which would be great. Because that, to me, that's an ignorant. I would much rather people be allowed to carry concealed than open carry. But whatever.
So the Tennessee law refers specifically to carry.
Not that I have either way. I think everybody should be able to carry the way they want. But out of the two, if I had to choose, I think it's more appropriate for more people to conceal carry than open. For some reason, everyone disagrees in most of the states.
Publicly or privately. Texas, the same story. If I were here defending a regime that just prohibited concealed carry and allowed open carry, I would have many, many, many more states. But I'm focused on just this type of law, and even there, our submission is there's a substantial history and tradition of that kind of regulation. It's not the sort of outlier that the court confronted in Heller and McDonald. And if I could speak to, Mr. Clement has spoken some about the case law from the 19th century and has suggested that laws like these were struck down. And with all respect to my friend, that's not correct. The cases that he is relying on are primarily dicta.
I ain't calling anybody on the left my friend. It may sound cool, and you guys may think it's cool to get along and to reach across the aisle and all that other bullshit, but the enemy of freedom is not my friend.
The two cases he has that actually struck down laws, the three cases that he has that actually struck down laws are the Nunn decision from Georgia, which struck down a law that was banned even the keeping of pistols. The court did say in dicta that open carry was required, but the law was actually much more restrictive than that. The Andrews case that he relies on and that Heller relies on as well is actually more helpful to us because the court upheld a prohibition on the carrying of belt.
This attorney is doing such a better job arguing his point and making points. And he could talk all day with facts. Whereas the other freaking New Yorker was, public safety, Times Square on New Year's Eve, public safety. Wow.
Or pocket pistols. And it prohibited a ban on revolvers only because the court construed that ban to be so broad that it would prohibit even carrying it around your house. And in the very next sentence, the court said, but of course the legislature, if it wanted to, could regulate the carrying of that firearm publicly. And then when you turn to laws like the ones that we have here, which include some sort of self-defense exception, either ex ante or ex post, the trend in the cases is in favor of upholding their constitutionality. We've cited about 6 decisions from the 1800s and the early 1900s, including the Duke and English cases from Texas, the Isaiah case from Alabama, the Haley and Fife cases from Arkansas, and the Workman case from West Virginia, all of which upheld those laws. And Mr. Clement's answer to those decisions is that they rested on the erroneous understanding that the Second Amendment or its state equivalents protected only the right to use arms in the militia. But that is not what those cases say. They do not stop by saying that the defendants were not militiamen and so had no rights. The Texas cases in particular in Duke and English say that the law makes all necessary allowances for self-defense by including the type of exception we described earlier. And so our submission is that that body of case law that New York law carries forward is part of our nation's history and tradition of firearms regulation, and that New York ought to be allowed to continue to make the choice that it has made. Now, we understand, and there's force to Mr. Clement's argument, that other states have made other choices. Justice Alito made powerful points about how some individuals have a powerful claim to have a gun for self-defense. But the question before the court is, of all of the different approaches to these difficult issues that states and other jurisdictions have taken over our nation's history, is this one that the Second Amendment takes off the table? And our submission is that when it's an option that New York has, and other states have had for a century or more, and that traces as far back as some of the laws that I've been discussing into our nation's history, that's an option that is consistent with our tradition of gun regulation and is an option that ought to be available to the states.
Justice Thomas? Justice Breyer? Justice Alito?
Is it correct that the Sullivan Law was an innovation when it was adopted?
It was relatively new. I think the Sullivan Law was 1911. The licensing requirement at issue here was 1913. I think Massachusetts had done something similar in 1906. Hawaii did its as well in 1913, and we view those as
Man, this guy's subject knowledge, he's on it.
lineal descendants and, in fact, improvements upon the sort of Texas laws, which made you prove self-defense at the back end rather than giving you a chance to demonstrate it up front.
There's a debate about the impetus for the enactment of the Sullivan Law, is there not? There are those who argue, and they cite support for this interpretation that a major reason for the enactment of the Sullivan Law was the belief that certain disfavored groups, members of labor unions, blacks and Italians, were carrying guns, and they were dangerous people, and they wanted them disarmed.
Much like they are in the big cities, high black neighborhoods. They don't want people carrying guns. Chicago, Detroit, Baltimore, you name it. But we can't say that because that would really state the facts. And instead, we'd rather blame the gun for the problems and penalize good people for the actions of bad people.
There have been those arguments made, and there's certainly evidence that those sentiments existed in New York at the time. I have not seen things that persuade me that those were the impetus for the Sullivan Law, and to the extent that that was a question, I think the fact that similar laws have been enacted and maintained, not just in New York and not just at that moment in time, but in a number of different states throughout the country, throughout large swaths of our nation's history, is a good reason to believe that this is not just prejudice, that this is a legitimate regulation.
I think one more question about the major point that you've made this morning, which is that there are scattered statutes, local ordinances, judicial decisions from various points in the 19th century, extending into the 20th century, the early 20th century with the Sullivan Law, and the other laws that you mentioned that are inconsistent with Mr. Clement's argument. But what does that show about the original understanding of the right that's protected by the Second Amendment? Would we be receptive to arguments like that if we were interpreting, let's say, the First Amendment or the Confrontation Clause of the Sixth Amendment? Would we say, well, you can find a lot of state laws and state court decisions from the 19th century, early 20th century that are inconsistent with a claim that is made based on the original meaning of a provision of the Bill of Rights, and that shows that's what that was understood to mean at the time.
Well, Justice Alito, I think Heller was receptive to those types of arguments and conducted a review of history through the 20th century, and rightly so. I think it's not unusual to look to the nation's tradition to understand the meaning of constitutional rights. I think that's especially appropriate here for a couple of reasons. One is that I think everyone agrees that the right codified in the Second Amendment is a right that is subject to some reasonable regulations, and in deciding what regulations are reasonable, we think the fact that they've been prevalent throughout our history is a good sign that they are. We think that's especially so because of a point that this Court made in McDonald, which is that throughout the nation's history, this is a right that's been recognized and codified in state constitutions as well. It's not something that people were not aware of. And so the fact that this type of regulation coexisted for so long with that understanding, we think is a particularly strong indication of its consistency.
Well, Heller, and I will stop after this, Heller cited decisions going into the 19th century as confirmation of what it had already concluded based on text and history at or before the time of the adoption of the Second Amendment. It said this is what it was understood to mean at the time, and it's further evidence that this is what this right was understood to mean because it kept being reaffirmed by decisions that came after. But I find it hard to understand how later decisions and statutes, particularly when you start to get into the late 19th century and the early 20th century, can be used as a substitute for evidence about what the right was understood to mean in 1791 or 1868 if you think that's the relevant date.
So you're certainly right about the way that Heller looked to decisions on its core holding of does the Second Amendment protect only a militia-focused right or an individual right. But when Heller turned to the question presented here, which is what sorts of regulations are consistent with the right that it was recognizing, I think it's fairly read to extend the analysis into the 20th century for the reason that Justice Kagan identified, that it validated as presumptively lawful felon in possession requirements, bans on the possession of firearms by the mentally ill that date to much later than the 19th century.
Thank you.
Justice Sotomayor?
What do you do with Heller and its recognition of categories of exclusion? Mentally ill, felons, domestic violence, presumably, although it didn't mention it. Can any of those ever pass strict scrutiny on their face?
I don't know. I think the lesson from Heller, though, is that you don't need to apply strict scrutiny or any other level of scrutiny because those are the types of regulations that are validated by our nation's history and tradition of gun regulations. And so we would take that lesson from Heller as exemplifying the proper mode of analysis and apply it here as well.
So what do you do with the view, Mr. Clement's view, that the essence that Heller says is that you do have some sort of right outside of the home to guns for self-defense. So how do you finish what you think that right is, or how do you describe it?
So we don't quarrel at all with the notion that the Second Amendment has something to say outside the home. Our submission is just that to understand how it applies outside the home, one has to look to the history and tradition of regulations. And what we've tried to argue in our brief and this morning is that there is a substantial history and tradition of the regulation of the public carrying of concealable weapons, including pistols, because of the dangers that they present, and that regulations of that type, of which New York's is one, are consistent with the right recognized in the Second Amendment.
Let's go to the extreme. There's no exception for a good cause. There's no exception for no exceptions whatsoever. No rifles for hunting, nothing. Outside the home, you can't possess any kind of ammunition-driven weapon.
Yeah.
Where would we be with that?
I think that is a type of regulation that fortunately no state has today, and that I don't think there's any historical precedent for. I don't think you could make this sort of argument for that sort of
So give
law.
me the limiting principle of what regulations and how far they can go that don't achieve that.
Right. So I think, like Mr. Clement, it's going to be difficult for me to give you definitive answers because, in our view, this is an inquiry that has to be driven by history and tradition, and that requires a careful examination of history and tradition. But let me give you a couple of guideposts. I think there is a tradition of laws like the Tennessee law that I alluded to earlier and others that prohibit the carrying of concealable weapons without any exception for self-defense or any good cause exception like the one that you have in the New York law. So we think, and Judge Bybee for the en banc Ninth Circuit concluded after an exhaustive historical analysis, that those types of regulations are consistent with the Second Amendment. But I acknowledge that that's a tougher historical case to make than the case that you can make with respect to laws like New York's that include self-defense exceptions.
Thank you.
Justice Kagan?
Mr. Fletcher, I think I probably should have asked General Underwood this question, but I forgot, so here you are. And the United States also has law enforcement officers, even though they operate differently from sort of the cop on the beat. But I'm just wondering if there is anything that you could say, any evidence that you can share. Are there studies? Is there information about how this actually affects how getting rid of this regime in the way that Mr. Clement would want this court to do, how it affects policing, how it affects the ability of police officers to keep the streets safe, and how it affects their own safety. Is there information about that? Are there studies?
I would actually say officers are safer when good people are carrying guns. If officers aren't out there being tyrannical and treating people like shit. in this day and age where cops are allowed to shoot anybody with a gun and shoot anybody no matter what they're doing, that's why it's dangerous. Cops create their dangerous situation, not good citizens with guns.
There are, I think the best place I can point you to for studies are some of the amicus briefs, including the social scientist brief that Justice Breyer discussed with my colleague, General Underwood. In terms of sort of the United States' perspective specifically, I don't have.
I'm assuming General Underwood is the general counsel for New York, but again, I didn't look that up.
Have any sort of quantifiable statistics. What I can tell you is that we do share the concern behind the New York law, which is the concern that having more guns on the street does complicate and increase the danger.
It pisses me off when someone's here arguing for more Second Amendment rights, and now they start throwing bones and they start agreeing with freaking bullshit Second Amendment right laws that totally ignore the Second Amendment right that says shall not be infringed.
Inherent in citizen law enforcement encounters. We do think that's a real concern, and it's one of a number of real concerns that are reflected in the law that New York.
I mean, do police officers stop people in the same way in notwithstanding what whether there are whether it's a New York regime or a more permissive regime?
I apologize. I don't have studies on that. All that I can give you is my own sense that if I were a police officer, I would certainly think prominently in my mind about what are the odds that the person that I'm stopping or approaching on the middle of the highway, late at night, is likely to be armed. And the licensing regime in the state is going to be an important factor in the risk that that's the situation.
So in your theory, Mr. Dumbass, now I'm calling the guy that's arguing the point a dumbass. In your theory, a person's going to go to the state of New York, apply for a license, go through a background, go through all the freaking hoops, pay all the money, answer all the questions and all the inconvenience and wait and delays. He's going to go through all that so when a cop pulls him over, he can shoot a cop. Are you a fucking idiot? Nobody going through this bullshit wants to shoot cops. Cops are only in danger by illegal people doing illegal things and using guns to create crimes. Not good people with guns. Quit mixing it up, you freaking idiots.
Thank you.
Justice Gorsuch?
Mr. Fletcher, in your brief, you suggest that the New York law passes both the text and history approach and an intermediate scrutiny. Should we apply that? And I guess I'd like to pose the same question to you that I did to Mr. Clement, and that is, what is the appropriate test between those two or others? The lower courts seem very divided over how to approach Second Amendment questions. Some apply the text and history approach to the challenge before them. Others say, yes, text and history is appropriate, but we're not going to extend the Heller right until and unless the court first does so. Through its own text and history analysis. We're not going to do it ourselves. Others have applied intermediate scrutiny. Others have applied what might be described as a watered-down version of intermediate scrutiny. And some have suggested strict scrutiny or some modification of it should apply. I'd just be grateful for your thoughts.
First of all, you idiots on the Supreme Court are not supposed to worry about what other people are doing. Your sole purpose for the Supreme Court is to defend the Constitution. That's it. You're not there to worry about history or what somebody thinks or what some lower court did or what some police officer might be scared of. Your whole entire job in existence is to defend the Constitution. Jesus Christ.
I appreciate the question, Justice Gorsuch. And I think our view is that courts ought to follow what we understand to be the lesson from Heller, which is that you start with text, history, and tradition, and when those sources provide you an answer, one way or the other, either that the law is valid or that it's invalid, you end there, and that's the end of the inquiry. We take that approach to be consistent with the approach described by Justice Kavanaugh in his dissent in Heller 2. I think the one place where we might differ from him a little bit is that we think there may come a point, especially as when courts confront new regulations, where history gives out, where it's not possible to draw those historical analogies anymore. And at that point, our suggestion is that the way to be faithful to history and tradition is to look to the broader method that you find in that history and tradition.
I'm kind of surprised that he pointed out Kavanaugh has not or was it Gorsuch? Who didn't agree? Kavanaugh. So Kavanaugh dissented against Heller too, and I'm not sure the difference between Heller and Heller too, but if you're one of these justices, and this case is quoting Heller, and you're one of these justices that voted against Heller, you think you're going to vote against this because they're citing Heller? I think you will.
And the method that we find in a half dozen or so cases from the mid-1800s that we cite is to ask whether the law is a reasonable regulation. And as we explain in our brief, we think that the modern judicial method that is most faithful to that approach is a form of intermediate scrutiny.
Thank you.
Justice Kavanaugh?
Thank you. Mr. Fletcher, appreciate your focus on history and tradition and want to explore that and get your thoughts on one thing. As you say, there is a history and tradition, and it exists to the present day, of permitting regimes. And so the issue before us will have effects, but it's a narrow legal issue of shall issue versus may issue, and it'll have substantial effects. But there is a tradition of permitting regimes. But how do we think about, do you think, kind of a separate tradition that the Chief Justice and others have referred to in our constitutional law of concern about too much discretion in exercise of authority over constitutional rights, and the too much discretion can lead to all sorts of problems, as our history shows. So you've got the tradition of permitting, but how do we think about, fold in just a general concern about too much discretion?
It sounds like the issue is they want the Supreme Court to change New York's may issue, and they want the Supremes to say all states should be shall issue. This would be a huge ruling if they did say all states should be shall issue. Not that it would change anything substantially, it would just put the burden of the government to prove and to jump through hoops on why they weren't issuing license versus in the may issue states to where they make the citizen, the pesky citizen, jump through hoops and justify why they should allow you to exercise your right with a license. Big difference.
So I appreciate that concern, and I think here's how I would think about it. First, I would say there is a substantial history of discretion in this particular area, starting out with juries in the Texas and West Virginia type regimes that I talked about now, moving into permitting officers. And I think that's inherent in any system. If you say a permit is going to be conditioned upon a showing that you have a genuine, specific need for self-defense, then someone's got to make the decision about whether or not you've made that showing. New York has decided it's best to do that by delegating the authority to local officers, local judges who are most familiar with local conditions. I do appreciate the concern about discretion, and I think if the court were to conclude that some sort of good cause, sort of self-defense-based exception is required, then the court might conclude that some more predictable or stringent or prescriptive guidelines are required, that you can't have that much discretion if the court concludes that that sort of good cause exception is actually constitutionally required.
Thank you. Appreciate it.
Justice Barrett?
Listen to this. I'm really confused on whether or not this guy is really arguing for the Second Amendment against New York, or is he supporting New York?
Thank you, counsel. Rebuttal, Mr. Clement?
Thank you, Mr. Chief Justice. Just a few quick points in rebuttal. First of all, I want to highlight that when the government was asked for its interest behind this permitting regime, it said that if it went to a different regime, it would multiply the number of firearms in circulation. In a country with the Second Amendment as a fundamental right, simply having more firearms cannot be a problem and can't be a government interest just to put a cap on the number of firearms. And that just underscores how completely non-tailored this law is. It might be well-tailored to keeping the number of handguns down, but it's not well-tailored to identifying people who pose a particular risk or anything else, because it deprives a typical New Yorker of their right to carry for self-defense. Second point I want to make is just about population density. There's been a lot of discussion about that, but it's very much a double-edged sword, because when there's a population density, that's an awful lot of people who all have Second Amendment rights. And so you can't just simply say we're not going to have Second Amendment rights in the areas where there's dense population. And I would say here experience does tell you a lot. By my count, 7 of the 10 largest cities in America measured by population are in shall-issue jurisdictions. And I've mentioned them, cities like Phoenix, Chicago, Houston. These are large cities where it hasn't been a problem. If you want to look at the empirical evidence, and I know, Justice Breyer, you asked about this, please also look at the English brief on the top side, because it's a very rigorous statistical analysis that shows that as a matter of actually doing statistics right, there's no difference here. And the only difference you really see is that people who have a handgun for self-defense end up with a better outcome. They're not shot. They're not made victims. But the English brief, I think, is really worth taking a look at. I want to say a quick word just about permitting. There may be limiting permitting in other contexts.
Okay, so I guess, and it doesn't really matter to me who they're fighting for. I'm just kind of talking. It sounds like that other guy is representing New York also, so they have 2 different people talking, that other woman and this other guy. And this guy, Mr. Clemente, is the one that's the Second Amendment guy, which is why I was confused. That other guy was like, dude, it sounds like you're arguing for New York. I thought he was arguing against it. But again, there's 3 different people arguing. Normally there's only 2. So I messed that up. Sorry about that.
Like parade permitting, but I'm not aware of any context whatsoever where in order to get a permit, you have to show that you have a particularly good need to exercise your constitutional right. And I think that is the absolute central defect with New York's regime here. I want to say a quick word about the history that my friend from the Solicitor General's office emphasized. It's telling that his first example is Tennessee.
Okay, I guess that's where the general comes from. He's from the Solicitor General's office.
If you look at the Heller decision, Tennessee is a problematic state in terms of its history. The court Tennessee Supreme Court first came out with the IMET decision, which the majority opinion in Heller criticized. It then came out with the Simpson decision and the Andrews decision, both of which protected Second Amendment rights, and the majority opinion in Heller praised those decisions at the same time that it criticized AMET. So to the extent there was an 1821 statute, I would put it in the same box as the AMET decision. Texas, which is their next example, and their only other 19th century example, if I heard my friend correctly, is even more problematic to rely on because Texas had a specific constitutional amendment that was similar to the English Bill of Rights but different from the Second Amendment that allowed the legislature to put specific restrictions on the right. So relying on 1871 Texas is highly problematic from a historical perspective, and that just leaves them with 20th century examples, which we concede, but by that point, the collective rights view of the Second Amendment was everywhere. Let me finish just by saying there's absolutely no need for a remand here. There are interesting statistics that could be developed, but none of them are relevant to the 2 central defects in this regime. First, that in order to exercise a constitutional right that New York is willing to concede extends outside the home, you have to show that you have an atypical need to exercise the right that distinguishes you from the general community. That describes a privilege. It does not describe a constitutional right.
Correct.
That is a sufficient basis to invalidate the law, but then there's the discretion. And the discretion here has real-world costs. If you want to look at it, look at the amicus brief in our support by the Bronx public defenders and other public defenders. The cost of this kind of discretion is that people are charged with violent crimes even though they have no prior record just because they are trying to exercise their...
Wow, public defenders came out. Wow, good job. Good job for them. I wonder if we'd be hearing this case if you had a jurisdiction that said, we're not issuing permits to women because we think they're emotional, and we're not going to issue it to black people because there's high crime in black neighborhoods. And historically, we can show that there's high crime in black neighborhoods. Therefore, applying this historic value, we're not going to issue concealed permits to black people. I wonder what their option would be then. Of course, it would be different.
Constitutional right to self-defense. And if you want to know how this impacts policing, one of the way essentially making everybody in New York City a presumptive person who is unlawfully carrying is that leads to stopping and frisking everybody. The framers, I think, had a different vision of the Fourth Amendment and the Second Amendment, and that is that individuals get to make their decision about whether or not they want to carry a firearm outside the home for self-defense. In 43 states, people are able to do that. It doesn't mean everybody ends up carrying, and it doesn't mean that those 43 states have any more problems with violent crimes or anything else than the 6 or 7 jurisdictions that don't honor the text, the history of the Second Amendment, and Heller. Thank you, Your Honor.
Thank you, counsel. The case is submitted.
So that means it's over.
We will hear argument this.
Well, look, this is a no-brainer for me. They're supposed to protect the Constitution. The Second Amendment says shall not be infringed, and any state that denies somebody the ability to protect themselves is wrong. No ifs, ands, buts, or coconuts. I don't care about with the history. I don't give a shit about anything. If you're denying a free individual, a pesky citizen, the right to carry a gun and defend himself, you're wrong. That's what it boils down to in my book. You can take it for yourself on what you want to do. We'll end that there. I normally don't say that. If you like these reviews that I'm doing, make sure and like all my videos, because if they don't get a lot of views, first of all, YouTube doesn't share them. And second of all, if I'm just wasting my time, then I won't do them. So let me know that my efforts are either wanted or they're not. All right, we'll end that there.